Okay, welcome to yet another installment of what they call Chicago's Best Ideas. I'm Marian Case, and the idea I'm going to talk to you about today is what I've been calling feminist fundamentalism, by which I mean an uncompromising commitment to the equality of the sexes that is as intense and, I would argue, at least as worthy of respect as, for example, a religiously or culturally based commitment to female subordination or to fixed sex roles. And I want to define myself as a feminist fundamentalist. I'm not necessarily proselytizing you, but I am at least outing myself. I am committed deeply and profoundly not only to the equality of the sexes, but in particular to its instantiation in what the Supreme Court of the United States has called the repudiation of, quote, fixed notions concerning the roles and abilities of males and females, unquote. These commitments are at my fundament, at my root, at my base, and my commitment to them is such that I would find it very difficult to act in ways inconsistent with them, as I think I can make clear by a couple of examples. First, you may recall that fairly recently, actually, only a couple of decades ago, the Southern Baptists declared that it was a wife's duty to submit herself, quote, graciously to the servant leadership of her husband, unquote. Nothing would induce me to submit graciously or otherwise to the leadership of my husband, and to avoid doing so, I would avoid acquiring a husband if necessary. Somewhat more controversially, there is also nothing that would induce me to veil in the way that many Muslim women willingly do as a precondition for appearing in public or in the presence of unrelated adult males. And this refusal to veil has consequences for, among other things, my freedom of movement. One consequence is, for example, that unless there is profound regime change, I will not be in a position to travel freely in much of the Middle East. I can't even enter Saudi Arabia because I will not veil. Now, of course, many people who would also identify themselves as feminists wouldn't share my difficulties. So for some Muslim feminists, the very act of veiling is a manifestation of their feminist commitments. Like the religious commitments to which I'm pressing analogy, these feminist commitments can vary in content as well as in character. Feminists, just like those within a faith tradition, diverge somewhat both in their beliefs and in their view of what their beliefs require of them. Moreover, many committed feminists, like many devout religious believers, would not embrace nor be accurately described by the term fundamentalism. Now, the way I'm using the term has a family resemblance, but not a perfect identity with the way the term is used in other contexts. What I mean by fundamentalism, which I'm going to distinguish from another word I'm using, perfectionism, which I'm also using somewhat differently than most people do, is principally an unwillingness to compromise. I think an example I can give you from the religious tradition may make that clear. I was once invited to a dinner party hosted by a Christian at which some of the guests were observant Jews, and on the menu was paella. Now, you may know that paella traditionally contains both pork and shellfish, which are both, to say the least, not kosher. This, I knew, the Christian hosts did not know, and they were surprised and horrified when the observant Jews explained that this was not simply something they should not eat. And they kindly suggested to the observant Jews that maybe they could just scoop out the pork and the shellfish. A fundamentalist is someone for whom just scooping it out is not an option. And a fundamentalist, in my view, is speaking sometimes only in the first person. Fundamentalism is, at minimum, about what I or we should or must, cannot or must not do. I'm distinguishing this again from what I'm calling perfectionism, by which I mean a desire to impose rather than an unwillingness to compromise. So a perfectionist is also speaking in the second and third person about what you and they should or must do, not just what I or we should or must do. So I hope you'll see that it's possible to be, with respect to any set of deeply held beliefs, either a fundamentalist or a perfectionist or both or neither. And that these positions, I think, are interesting to contemplate in a variety of ongoing debates, to use examples I can talk about, concerning civil marriage in the United States, failing in sex segregation, abortion, and the teaching of values in public schools, for each of which there are religious and non-religious, feminist and non-feminist, fundamentalist and perfectionist, non-fundamentalist and non-perfectionist positions. And I want to concede that for each of these views, bans on abortion, commitment to veiling, sex-segregated public spaces can not only be reconciled with some other people's feminist commitments, they can be endorsed as feminists or defended by feminist arguments with them. But one of the things I want to argue is that asking me, given my particular feminist fundamentalist commitments to veil, should be seen as in pari materia with asking devout Muslim women not to veil. So one conversation that I want to interrupt is the conversation in which religious believers demand respect for their religious belief, and when something comes in on the other side, it has trouble getting the same amount of deference or respect. So for example, it seems to me that too little attention has been paid in the discourse around these matters to the duties of the liberal state to accommodate the religiously fundamentalist individual. Although there's a vast literature there is a vast literature on the duties of the liberal state to accommodate the religiously fundamentalist individual, but there is not, as far as I can tell, much discussion about the religiously fundamentalist state duty to accommodate the liberal individual, such as myself. I also think there needs to be more conversation about the fact that liberal states, including this one, can and do have commitments, including fundamental and indeed fundamentalist commitments. So too often we set up a tension between feminist or liberal universalism on the one hand and local cultural commitments on the other. This puts me in some company that I'm a little hesitant about acknowledging, such as that of the recently assassinated Dutch politician Pim Fortuyn, who kept insisting that we in the liberal feminist constitutional West have our localized cultural commitments too, which are at least as important to us and as entitled to protection as the local commitments of others are to them. And I agree with Fortuyn that our commitments include equality and freedom with respect to sex and gender. And one of the things that motivates me in pressing for feminist fundamentalism is that I'm honestly of the view that what we are experiencing here, which is a group of males and females unrelated to one another, promiscuously intermingled, discussing something other than their sex lives, is as fragile and endangered a practice as any of the cultural practices of, for example, the tribes of Papua New Guinea or the Bushmen. And it's as extraordinary in long history and as rare on the face of the earth, and I think it needs to be defended. And that doesn't mean to say that these commitments are identical across the liberal constitutional West. Just as shared commitments to the principles of Christianity and Islam work themselves out importantly different ways among different denominations or communities of believers. Let me give you an example for this as well. There's been famously a diversity of responses among the signatories to the European Charter of Human Rights, all of whom share commitments both to sex equality and to freedom of religion on the question of veiling by Muslim teachers and students in state-sponsored schools. Now, one of my problems with the way this has worked out is that the local cultural norms that get the overwhelming majority of the attention are those pertaining to religious neutrality rather than sex equality, but that doesn't affect, I think, the usefulness of the example as an illustration. If you remember what happened in France, the fundamental constitutional principle of laïcité, or secularism, was used as a justification for banning all veiling, even by students, let alone by teachers, in public schools. A similar long-standing commitment to secularism led to a similar result, now being challenged by legislation, in Turkey, But in other countries, other results prevailed. My personal favorite, because it contains what may seem like a paradox, is the British response. The British case involved a student who attended a school whose population was majority Muslim, whose board of governors was majority Muslim, whose principal was a Muslim, and which accommodated a certain amount of covering by students. But she felt that this covering was not as extreme as she needed now that she'd reached puberty, and demanded the opportunity to put on a jilbab, a more all-encompassing veil. And the school said, no, we've very carefully reached a compromise with our Muslim student body, and this compromise would be endangered by accommodating you. And ultimately, the British House of Lords agreed with the school in an opinion in which Lord Hoffman described what I can only call an uncompromising commitment to compromise. He said that the fundamental British value of compromise meant that even religious believers needed to defer. Now, I happen to be contingently lucky that my own personal feminist fundamentalist commitments are pretty close to those embodied by the constitutional order in which I live. So one of the things I want to argue to you is that we have an orthodoxy, and I'm using these religious terms like orthodoxy and heresy and anathema advisedly. I do mean to press the analogy. But we have an orthodoxy with respect to sex equality in the United States, enshrined in Supreme Court case law, and that holds, among other things, that fixed notions concerning the roles and abilities of males and females are anathema when embodied in law. Now, some have said, well, it's convenient for you that you've probably just imbibed the orthodoxy of your nation state. Well, I'm actually old enough to have gotten there before the Supreme Court of the United States did. So before even the first decision striking down sex-respecting rules on the grounds that they were discriminatory, I was trumpeting these values. But I realized my contingent luck in having this orthodoxy adopted by my nation state. And the evidence that it really has been adopted, I think, is best seen in an opinion many of you may know, written by, of all people, Chief Justice Rehnquist, who came really late to the idea that discrimination on grounds of sex was a problem, and even later to the idea that there might be a problem when the discrimination was not in favor of men and against women. But he got there before he died. He wrote, as one of his last important opinions, the majority opinion in the Nevada Department of Human Resources against Hibbs, that reaffirmed that we have so strong and well-established a constitutional orthodoxy on matters of sex and gender, an orthodoxy that's not simply of sex equality, but of no governmentally endorsed sex role differentiation in all matters, including those related to family and child rearing, that Congress has prophylactically got Section 5 power, Section 5 of the 14th Amendment, to enforce it on the states. So thus, to fight the longstanding, and I would argue now heretical, quote, pervasive sex role stereotype that caring for family members is women's work, unquote, Congress can impose on the states as employers the Family and Medical Leave Act, which says that persons of both sexes, not just mothers, not just women, can get leave for their own illness and those of close family members, as well as to care for their own young children. So what I want to argue, and again I'm pressing a religious analogy, is just as, for example, the new Constitution of Iraq or the more long-standing Constitution of Pakistan says, and I'm quoting the Iraqi Constitution here, no law that contradicts the established provisions of Islam may be established, unquote. So the equality of the sexes is up there with racial equality and with the non-establishment of religion among the very few commitments that the existing U.S. constitutional order makes fundamentally binding on government whenever it acts or speaks. And as with racial equality, I would argue that this is an orthodoxy. It's incumbent on government to follow through in all fields, in hortatory pronouncements, in funding decisions, in necessary interventions in the private sphere, including in the family. So government can, as speaker and dispenser of subsidies, take a large number of positions, but one it cannot take is the one that you may recall Justice Bradley putting forth in a 19th century case called Bradwell v. Illinois. He said there that the natural and proper timidity and delicacy which belong to the female sex evidently unfits it for many of the occupations of civil life, unquote. That's not a position the government can any longer make its own through subsidies, through hortatory pronouncements. So what might this mean in practice? For example, in 1993, the commissioners of Cobb County, Georgia, adopted resolutions proclaiming, among other things, that, quote, the traditional family structure is in accord with community standards, and lifestyles advocated by the gay community are incompatible with those standards. Cobb County will not fund activities which seek to contravene these existing community standards. If by the traditional family structure, the commissioners had explicitly indicated that they meant not just a heterosexual couple, but a patriarchal one with wives submissive to husbands and confined to the domestic sphere, as Justice Bradley would urge, I would argue that the resolution would violate existing constitutional equality norms, because lifestyles advocated by the feminist community can no longer be incompatible with the official community standards of any unit of government in the United States, including Cobb County. So if they were to put up a sign that said, welcome to Cobb County, where a woman's place is in the home, this would be a combination welcome mat and no trespassing sign with serious constitutional problems. Gets even worse when the government seeks to use its powers to fund or regulate to promote such a problematic message. This, I think, is a particularly urgent issue at the moment when the federal government is increasingly interested in sending messages about appropriate family structure and sexual behavior backed by carrots and sticks. For example, even assuming arguendo that a government of limited and enumerated powers like our federal government has the power to promote marriage through subsidies, whether hortatory or other, and hortatory and regulatory means, still constitutionally constrained only to promote egalitarian marriage. So a federally sponsored program that teaches the way to have a successful marriage is for wives to be submissive to their husbands, I would argue would have constitutional problems. And when the Department of Education funds a PBS television series, Postcards from Buster, I don't know whether any of you have seen this series or read about it, which is specifically designed to showcase the diversity of American families, especially when such a series unproblematically includes a Muslim family who veils their 12-year-old daughter, as well as evangelical Christian and Mormon families. There's serious constitutional problems with what Secretary of Education Spellings did, which is to force out of the series an episode featuring Jillian Piper and her partner, a lesbian civilly united couple from Vermont, who ran a maple sugaring operation with their 3 children. The series was called Sugaring, which I assure you is not, as Secretary Spellings may have thought, an obscure sexual practice, but it really is about getting maple sugar. So when Justice Souter dissented from the school voucher case, he wrote that, quote, not every secular taxpayer will be content to support Muslim views on differential treatment of the sexes, or for that matter to fund the espousal of a wife's obligation of obedience to her husband, presumably taught in any school adopting the Articles of Faith of the Southern Baptist Convention. I'm going to go a step further than Souter did and say that it would already be unconstitutional for the government to fund this sort of teaching in the same way as it has been held unconstitutional for the government to fund racial segregation. And I think this also has messages for the limits on the messages state-sponsored schools can offer. They're required, they're not only permitted, as was established many years ago, but they're required to refrain from promoting a message of inequality between men and women. Unfortunately, though, when one moves beyond institutions covered by Title IX, there's been to date too little in the way of regulatory attention paid in the U.S. to ensuring that the education provided to students through state-regulated private and homeschooling, even minimally, communicates or comports with norms of sex equality, and I'd like to see that change. Although I concede that what it might mean in practice for sex equality norms to operate as a necessary constraint on state action is particularly tricky when that state action involves children. But as has been clear for some time, when it comes to state laws governing such matters as alimony and child support, sex equality norms should also constrain government on those occasions when it necessarily adjudicates concerning the family. So take the situation where the state is already involved in family disputes. For example, a custody dispute between two already recognized parents. That's not something the state can stay out of. It's got to make a decision, and I would argue that just as Palmer versus Sidoti established long ago that race discrimination was not something the government could be involved in making these sorts of decisions. So today, sex discrimination is also not something the government can be involved in, and therefore the state should not select in a competition between otherwise qualified competitors for parenting those who believe or would teach that females are inferior to and ought to be subservient to males. But unfortunately, as things now stand, in custody disputes, when repressive religious beliefs are pitted against secular feminist ones, judges tend to give these religious beliefs a presumption of respect. I want to insist it's even more deserved, although not often granted, to the feminist ones. So one frightening example for me is the case of a woman named Lori April Lang, whose husband subjected her in his church to an exorcism to rid her of evil, unsubmissive spirits. I'm quoting from the opinion here. Spirits which caused her to speak up for herself and to exercise authority rather than completely submit to her husband, unquote. The exorcism obviously didn't work because she sought a divorce instead. But she then found the court adjudicating custody unwilling seriously to consider whether her husband's religious convictions and his efforts to pass them on to his son might adversely affect her relationship with her son. Even some courts that rule against parents who claim religious authority for sexist beliefs and practices often do so without giving explicit consideration to the role constitutional norms of sex equality should play in this decision making. For example, there was a Virginia judge who did terminate a father's visitation with his son and daughter after hearing, first of all, testimony by a clinical psychologist that the daughter is particularly at risk of psychological damage because of her father's telling her that women should not strive to accomplish what men accomplish and that they're supposed to be subservient to men. And secondly, evidence that the daughter, who was, quote, an excellent student, unquote, did better in school in a year in which no visitation occurred than in a year in which there was visitation. And finally, that the father had told both children that they and their mother were sinners and were going to hell. The judge concluded that this visitation was causing serious psychological and emotional damages, in no small part because the values being taught to the children by the father were different from the values taught by the mother, and acknowledged that among this conflicting set of values were that the mother encourages the children to be whatever they want to be, and the father tells his daughter women cannot do what men do. But even with respect to those values, the judge insisted whichever set of values is right, and the court makes no judgment on which set of values is right. They are irreconcilably at odds. So it may well be true that as between tolerance on the one hand and fire and brimstone on the other, a court can make no judgment. But I would argue that a court is constitutionally compelled to choose encouragement of a daughter's unrestricted choice of occupation over a fixed and subordinating message that women should not strive to accomplish what men accomplish and are supposed to be subservient to men. Somewhat more controversially, I would say the same when the dispute is not between a religious but a culturally based commitment to fixed sex roles or female subordination. So that I think it's also appropriate, for example, in a custody case between two unmarried parents, both of them immigrants, one the father legal, the other the mother illegal, to take into account not only the father's legal status, but the fact that when in the mother's custody, the daughter was kept at home to take care of other family members, unwillingly kept out of school. Now, let me talk a little bit about some of the other feminist fundamentalist individuals that I think deserve a little more respect from the legal system than they're getting, in hopes that you will agree with me that existing constitutional law is a strong lever for them. One such group is heterosexual marriage resistors, and who I think are actually the real losers in the ongoing debates about same-sex marriage. Because take, for example, those many states who have set up separate institutions for same-sex couples, reserving the name of marriage for heterosexual couples because of and not in spite of its traditions. It seems to me that the traditions of marriage are at the very least about fixed sex roles and have even more so been about female subordination. So that women who, to get their relationship to a man recognized, are forced to do so by law in an institution reserved for them alone because of and not in spite of its traditions, have suffered an expressive injury and have cause for complaint. The recognition of civil union status may have made same-sex couples much better off, but it has, I think, hurt the situation of heterosexual women from a feminist perspective. And that gets even worse when you see that some of the courts that have rejected rights for same-sex couples have done so specifically invoking fixed sex roles and the differences between men and women as a justification. I've had occasion to say in this room before that the judge who wrote the New York same-sex marriage opinion saying to same-sex couples they had no right to marry under New York law, gave as a justification, among other things, that it was important for children to see before them on a daily basis what a man and what a woman are like. Now, I know this judge, and what I said to him is, you must be arguing for more nudity in the home, because as a matter of constitutional law, a man and a woman are not like anything in particular. But again, sex roles are on their way back, which comes to my sense of threat and the need for defense. So who else are feminist fundamentalist individuals? Well, some of you may have encountered the case of Darlene Jesperson, who was a successful bartender in a Las Vegas casino for many years, until her employer decided that unless she were going to wear makeup, she couldn't keep her job. And what makes me think that Jesperson is a feminist fundamentalist, although I've never met her or spoken to her, is that the reported case, quote, describes the personal indignity she felt as a result of attempting to comply with the makeup policy. She testified that when she wore the makeup, she felt very degraded and demeaned, and that it prohibited her from doing her job because it affected her self-dignity and took away her credibility as an individual and as a person. Now, unfortunately, a majority en banc of the Ninth Circuit completely disrespected those commitments, describing Jesperson as idiosyncratic and the rules of the casino that employed her as neither rooted in sex stereotypes nor posing an undue burden on women. One of the few dissenters was Judge Kaczynski, whom you may have had the opportunity to hear yesterday, and he, I think, got it. He said, like Jesperson, Alex Kaczynski, would find such a regime burdensome and demeaning. It would interfere with my job performance. I suspect many of my colleagues would feel the same way. Everyone accepts this as a reasonable reaction from a man, but why should it be different for a woman? It's not because of anatomical differences. Women's faces, just like those of men, can be perfectly presentable without makeup. It's a cultural artifact that most women raised in the United States learn to put on and presumably enjoy wearing cosmetics, but cultural norms change. A large and growing number of women choose to present themselves to the world without makeup. I see no justification for forcing them to conform to Hara's quaint notion of what a real woman looks like. So Jesperson's account of her reasons for refusing to put on makeup sound to me like a feminist fundamentalist parallel to the cases of Muslim women who won't unveil, and a feminist fundamentalist twin of the following case, which I'm going to end with. It's the case of Colonel Martha McSally, who would not veil. She was an Air Force fighter pilot stationed in Saudi Arabia with the US Air Force, and she brought a court challenge to regulations that required all female military personnel on all trips off base from Saudi Arabia to be accompanied by a male companion, whom they were told falsely to say was their husband. and to wear an abaya, which is the full body covering, which is the Saudi Arabian instantiation of the Islamic requirement of hijab, or modest covering of women's bodies. Now, before she sued, she tried unsuccessfully but vigorously to get the regulations changed within the military hierarchy, but finally she brought a complaint saying that these regulations violated her constitutional rights for several reasons. Among them, that by forcing her as a Christian woman to persuade herself as a Muslim and put on Muslim garb, this violated her free exercise of religion, and that she was also forced to communicate the false and coerced message that she adheres to the belief that women are subservient to men, and this violated her right to equal protection on grounds of sex. A couple of things should be made clear about her situation. First, these were requirements not of Saudi law, but of the US military, so that other female US government personnel, such as State Department employees, were not required or encouraged to do this. And secondly, that male US military personnel were not only not required, they were categorically prohibited from wearing local dress. And McSally gave practical examples of how the rules undermined her authority and were counterproductive to their intended purpose, given that the local religious police, who might have left her in peace had she been lightly veiled and obviously a Westerner, treated her in an abaya as coming more fully within their jurisdiction and held eligible for punishment for minor transgressions, such as letting her abaya slip. Of all the people I'm calling feminist fundamentalists, she's one of the few who has not been a loser under the American legal order, but I think it's instructive to see exactly how and why she won. She didn't win in the courts. She won in the Congress of the United States, which by a voice vote directed the US military not even to suggest, let alone enforce, such a policy as veiling to female military use personnel in Saudi Arabia. But if you look at the debate that preceded this voice vote, 90% of it was about how this poor Christian woman should not be forced to portray herself as a Muslim, and almost none of it was about the feminist claim, which I think was equally central to McSally based on her subsequent conduct. And her subsequent conduct includes, unusually for a dissenter to military policy, promotion. She was promoted to a position no women had previously held, and she showed up for the installation ceremony in the male version of the Air Force cap appropriate to that position. Maybe news to some of you that there are male and female versions of Air Force caps. I'm told that this is to accommodate women's hairstyles. But in any event, she chose the male version of the cap, which makes me think that the notion of no fixed notions and no fixed wardrobe for males and females is important to her. And I'm sorry that the US Congress did not take as seriously the feminist fundamentalist claim as the Christian claim, and I'm hoping that in future I can persuade them to do so. Thanks.